Okay, the person that's on Zoom, uh,
Yes, sir.
put your mic on mute. And then once we finish doing the arraignment, um, we'll reset your case. Thank you. Okay. Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today for what is called an arraignment. And what the arraignment is, just an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning the case. Now, the case that you have in this court is a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. Now, when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are convicted of the offense. Now, felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to maximum 20 years and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life in the state penitentiary, or a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you, you have a misdemeanor case, so you don't have to worry about those type of punishment. Misdemeanors are divided into 3 categories. We have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor, which is the lowest misdemeanor. Now, if a person is convicted of a Class C misdemeanor, the range of punishment is a fine that cannot be above $500. So you can't get jail time, it's just a fine only. Now, Class C misdemeanor cases start in the city court or the JP court. They come to this court when a person is found guilty in the city court or the JP court and they appeal their case. They get a whole new trial. It comes to this court. The punishment range stays the same. That is, the fine cannot be above $500. Now, if a person failed to pay the fine, or if they the fine was converted to community service and they failed to perform the community service, then the court can issue what is called a capias pro fine. It's just a warrant for the person arrested for them to pay the fine. Now, if they cannot pay the fine, then they can sit the fine out in jail. And for every 1 day that they sit in jail, $100 will be credited toward their fine and court costs. Okay, now the next highest misdemeanor is a Class B misdemeanor. The Class B misdemeanor, the range of punishment is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail. Or you could be given a fine that does not exceed $2,000, or you could be given both such jail time and a fine. Now, the highest misdemeanor is a Class A.
Now, see,
then the highest misdemeanor is a class A misdemeanor. And with the class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is 1 year in the county jail, or a fine that does not exceed $4,000, or you could be given both jail time and a fine. Now, you may be eligible for probation. There are two types of probation. One type of probation is called unadjudicated probation, unadjudicated probation. And we commonly refer to it as deferred adjudicated probation. What that basically means is, if you get on probation, you don't have a conviction on your record. And if you successfully complete the probation, the case will be dismissed, and you can get what is called a non-disclosure. Non-disclosure means that your record, in this case, will be sealed to the general public. So the general public cannot have access to it. Now, the operative word that I use is general public. Now, there are certain governmental agencies that can have access, like the police department. And those agencies are listed in the Texas Code of Criminal Procedure, but most of the public is the general public, so most of the public cannot have access to it. So let's say you apply for a job at Exxon, and let's say you had a case, you had deferred adjudication or unadjudicated probation, you got a non-disclosure, you go to apply for the job, they do a criminal background check, that case that you had the non-disclosure on will not pop up. Why? Because they cannot have access to it. They're part of the general public. Okay? Now, the next type of probation, first type I said it was unadjudicated probation. The next type of probation is called adjudicated probation. We normally refer to it as regular probation. Now, with the regular probation, you do have a conviction on your record. However, there is something that is called judicial clemency, where the judge can set your conviction aside when you will no longer have a conviction. Now, in order to qualify for judicial clemency, 3 things has to happen. 1, you have to successfully complete the probation. 2, there cannot be any more time left on your probation. And 3, the probation office has to discharge you or let you off probation. If those 3 things happen, then the judge has the discretion to set that, to give you what is called judicial clemency. Okay, where the conviction is set aside. Now, however, and so you won't have a conviction on your record. Now, however, if you get another conviction later on, then they call that a subsequent conviction. If you get a conviction later on, and you try to apply for first of all, if you get another conviction later on, once you get that conviction, then the conviction the case that you have judicial clemency on can be resurrected, revived, or brought back up and used against you. And if you try to get a license with CPS, which is Child Protective Services, they could deny giving you a license, or if you have a license, they can revoke or suspend your license. All right. Now, everyone here for arraignment, you should have a clipboard. Who does not have a clipboard? You do that? That's right. You're here for arraignment. Once you get that, that's clipboard right there by you. Okay. I'm going to go over that clipboard with you. Okay? Now, that first document on the clipboard should be titled Judge's Explanation of Rights to Defendants Without Attorney. And that document looks like this. I'm going to go over this document to you. I'm going to continue. I'll constantly refer back and forth to this document. Okay. Now, this document says that as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. Number 1, you may hire an attorney. Number 2, if you want an attorney, but you can't afford to hire an attorney, you may request that an attorney be appointed to represent you. And number 3, if you would like to waive or give up the right to have an attorney, you may represent yourself. Now, the first sentence under number 3 states that if you want an attorney, you have enough money to hire an attorney, the case will be reset. Reset means that you'll be given another court date from today to give you time to hire an attorney. The next one sentence paragraph states that if you want an attorney, but you do not have enough money to hire an attorney, then you may request or you may ask the court to appoint an attorney to represent you. But you must first fill out a financial questionnaire. Now, a financial questionnaire is a 3-page document that is also on the clipboard. And it looks like this. Now, before I go any further, this is only for people who will be applying for a court-appointed attorney. If you are not applying for a court-appointed attorney, you don't have to worry about this document. All right? If you're applying for a court-appointed attorney, again, you have to fill out the first page of this document, which is Jefferson County Affidavit of Indigence, and the second page at the top where it says defendant's oath, and then the middle portion that says unsworn declaration by defendant, and then you stop. All right. Now, going back to the first document, the next sentence is, which is the third sentence below number 3, is for people who will be representing themselves. So if you are representing yourself, that is, you don't want to have an attorney to represent you, you want to be your own attorney, then you'll have an opportunity to talk to one of the assistant criminal district attorneys. We call them prosecutors. We have 2 in court today. Okay. Good morning. Okay. You'll have an opportunity to talk to them. Why would you have an opportunity to talk to them? Because just like your attorney would be able to talk to them to see if they can negotiate something, you'll have the opportunity to talk to them too. Why? Because you are your own attorney. Okay. So this one sentence paragraph, the third sentence states that you may not talk to the prosecutor unless you first sign a waiver of your right to have an attorney. That is, you have another document on the clipboard. Now, this is only for people who will be representing themselves. If you're not representing yourself, you don't have to worry about what I'm getting ready to say. If you're going to represent yourself, you will sign this document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. Okay? You'll read this document, sign it, date it, and then you'll stop. Now going back to the first document. This paragraph that's right here, the 4th paragraph, that's for individuals who will be representing themselves, and it says this. The dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Now, the last sentence, one sentence paragraph down here, is for people who will be representing themselves. It states this. If you're representing yourself, you may change your mind at any time and ask that a lawyer be appointed to represent you. So, for example, let's say you decided that you want to represent yourself. And let's say you want deferred adjudicated probation or unadjudicated probation. You just want probation, period. And let's say you talk to the prosecutor. And the prosecutor said, well, I'm not going to offer probation. I'm going to offer you a fine, or I'm going to offer you jail time. And you say, well, I don't want that, Judge. I would like to have an attorney represent you. In essence, you will change your mind. So if you're representing yourself, you can change your mind at any time and ask for an attorney, that an attorney be appointed to represent you. All right. Now, at the bottom of this document, in bold letters, it states defendant's choice. mark initials next to only one choice. Now, everybody is gonna make one choice here. If you would like to hire your own attorney, then you will place your initials on the first line to the left. That's for individuals who like to hire their own attorney, and then you'll sign at the bottom where it says defendant, and you would date today's date, March 3rd, 2026. If you have already hired an attorney to represent you, then you'll place your initials on the second line to the left, and the name of the attorney on the line to the right. Then you'll sign at the bottom of the document where it says defendant, dated today's date, and then you stop. And this be the only form that you would have to sign. Now, if you are asking the court to appoint an attorney to represent you, then you will place your initials on the third line to the left. Right here at the bottom, third line. Sign where it says defendant, dated today's date, and then you will fill out the document that is titled Jefferson County Affidavit of Indigence. You will fill out the entire first page. Once you finish filling out the first page, you go to the second page, and then you will fill out the top portion that is titled Defendant's Oath, and the middle portion that's titled Unsworn Declaration by Defendant, and then you'll stop. You don't have to worry about the third page. All right, now going back to the first document. If you've already been appointed an attorney to represent you in this case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. Yeah, on the line to the right, and then you will stop. This is the only document you would have to sign. All right? Now, if you would like to waive your right to an attorney, that is, give up your right to have an attorney, and you would like to represent yourself, then you will place your initials on the last line, which is the fifth line to the left. You will sign and date it at the bottom. And then you will have to fill out this document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea. All right. So just as a little brief recap, if you are representing, if you want to hire an attorney, or if you have already hired an attorney, or if you have you already had an attorney appointed to represent you, this is the only document that you would have to sign. One document, that's it. You don't have to worry about anything else. If you're applying for a court-appointed attorney, then you would have to sign this document, third line, and then fill out the document that is titled Jefferson County Affidavit of Indigence. First 2 pages. And if you would like to represent yourself, then you place your initials on the fifth line to the left and fill out the document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you understand? Do we have any questions? Okay, no questions, all right? Yes.
Okay, he's disabled. I have his power of attorney on his mom.
I mean, we'll have somebody to assist him with filling it out.
Okay, I filled it out.
Okay, that's fine.
Yeah. Okay.
Yeah, but we'll, once all the paperwork is filled out, we're gonna pick it up and we're gonna check it to make sure everything is cool. Okay, yes. Yes, there's 2 restrooms, there's a female restroom right down the opposite side of the hall. Okay, yes,
You said if we represent ourselves, we should fill out this one, second one?
that page, yeah, and then you'll put your initials at the bottom on the 5th, yeah, right. Yeah, it's the 5th, right. And then you're gonna sign it and date it today's date, March 3rd, 2026. And on that one, you're gonna read that and then you're gonna sign it. That the one you have in your left hand, right. You're gonna read that form, you're gonna sign it, and then you're gonna date it today's date, March 3rd, 2026. Okay?
Thank you.
Okay. Now, as I mentioned to you earlier, arraignment is just an opportunity for the court to tell you what you've been charged with. what your rights are and what your options are concerning the case. Okay. Now we're gonna talk about, all right, we talked about the right to have an attorney. Another right that you have, well, first of all, let me do this here before I get to that. You can enter a plea, one of three pleas. You can plead guilty. If you plead guilty, you're telling the court that you committed the offense that you've been charged with. Or you can plead not guilty. If you plead not guilty, you're telling the court that you did not commit the offense that you have been charged with. Or you can enter a plea of no contest. No contest means you're telling the court that you will not be fighting the charges or you will not be contesting the charges. All right? You can enter one of those three types of pleas. Now, let's say you enter, well, everyone here have a right to have a trial. Okay? When a young man is sitting, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all of the evidence that's presented by the state, by the defense. They'll listen to the arguments of the state and the defense, and then they will go back into the jury room and deliberate. And then they can decide to find you either not guilty or guilty. You can waive or give up your right to have a trial by jury. Now, when I say waiving or giving up your right to have a trial by jury, you say, well, I don't want to have a trial by jury. Now, if you say that, well, you still can have a trial. We call that a bench trial. A bench trial is a trial by judge only. Well, the judge will be the judge and the jury in the case. Okay? The judge will listen to all of the evidence that's presented by the state, by the defense, listen to the arguments of the state and the defense, and then the judge will apply the facts of the law and decide to find you either not guilty or guilty. Now, you can waive or give a right to have a jury trial, and you can waive your right to have a bench trial. If you do those, basically what you're saying is that you enter a plea of either guilty, where you say that I committed the offense that has been charged with, that I've been charged with, or I'm entering a plea of no contest, meaning that I'm not contesting or fighting the charges. If you do that, then you can have a right to have what is called enter into what is called a plea bargain. Now, what a plea bargain is, it means that your attorney can talk to the state, to the district attorney, or you can talk if you represent yourself to see if you can work out something. We call that a plea bargain. If you come to an agreement, we call that an agreed plea bargain. If you come to agreement, then you have to go before the judge for the judge to either accept or reject the agreement. If the judge rejects your agreement, guess what? You can take your plea of guilty back. For example, you wanted to get probation and state offered you probation, go before the judge said, well, I'm gonna reject that. And he said, well, judge, since you're not accepting our agreement, my agreement, I take my plea back. In essence, I'm not pleading guilty and I'm not pleading no contest. You can do that. All right. Now, if the judge follows the plea bargain agreement and say, let's say within 30 days, because you have 30 days to file a motion for new trial or appeal, you say to yourself, you know what? I think I've been wrongfully convicted, or the court committed an error by convicting me. I like to appeal my case. If you like to appeal your case, then you have to go back to the judge who granted the plea bargain, who accepted the plea bargain agreement, and you have to get the judge's permission to appeal. If the judge gives you permission, guess what? Your case is going to leave this court. And it's going to go upstairs to the Ninth Court of Appeals where there are 4 judges up there. They can review your case. They can do one or two things. They can grant or deny your appeal. If they grant your appeal, they can simply find you not guilty. Case over. Or they can deny your appeal, and if they deny your appeal, guess what? You can can appeal it to another court. You could appeal it to a higher court than the Ninth Court of Appeals. In essence, you could appeal it to the highest criminal court in the state of Texas, which is called the Texas Court of Criminal Appeal. They're located in Austin, Texas. Now, you would have to file what is called a petition for discretionary review. Petition means that, I'll explain it to you. It's a pro se petition for discretionary review. I'll explain it to you. Pro se means self, I'm by myself. I don't have a lawyer. I'm asking the Texas Court of Criminal Appeals to review my case, to see if the Ninth Court of Appeals should grant my appeal, or if this state committed the error by convicting me of basically wrongfully convicting me. They could do one or two things. They could grant or deny your petition. If they grant your petition, they could simply find you not guilty in case over. Or if they deny it, then at that point, your conviction will stand. Okay. Now, I mentioned that, you have a right to enter plea bargains and stuff like that. And you have a right to have a jury trial. You have a right to have a bench trial. That's a trial by judge. You also have a right to have witnesses that come to court and sit in that chair that has the microphone in front of them. That's called the witness stand. Witnesses can testify for you or against you. If you represent yourself, you can ask some questions. If you have a lawyer representing your attorney can ask some questions. We call that either direct examination or cross-examination. Now, you can also waive or give up your right to have witnesses, which means that you will not be calling witnesses in your trial. However, that does not mean that the state will not be calling witnesses, because they will be calling witnesses. Now, you also have what is called a Fifth Amendment right against self-incrimination. That means that you have a right to remain silent. And it comes from the Fifth Amendment of the United States Constitution. Now, I know a lot of times we watch television, we see Law and Order, we see a television lawyer that go up to the witness stand and ask the witness a question. And the witness say, I take the fifth. What the witness is saying is that I'm invoking or exercising my Fifth Amendment right against self-incrimination. I'm not saying nothing. Okay? You have a right to do that. And if you think about it, it makes sense. Why does it make sense? It makes sense because of this. The state has the burden of proving you guilty. They have to prove you guilty. You don't have to prove yourself guilty. Okay? That's why it makes sense. So if you remain silent, you have a right to exercise that right to remain silent. Now, you can waive or give up your right to remain silent. And that's when you can say, well, yeah, I want to say something. I want to testify. Now, you'll be waiving or giving up your right to remain silent. Okay. Now, the other right that you have that I'm going to talk about is your right to have what is called discovery. They call it discovery, and basically what it means, you have a right to see what's in the state's file. You have a right to see the evidence. You have a right to see your statements, witness statements, police reports, lab reports. You have a right to listen to audio recordings, see video recordings, see photos, see documents, and any type of instruments that they have, whatever evidence that they have, you have a right to have access to that. Now, you can waive it, which means you can give up your right to have access to it and say, well, I don't want to see it. Okay? And so you have a right to waive or give up your right to have access to it. Now, everybody that's here for arraignment, charges been filed on, you've been arrested, you've been placed in the county jail, you bonded out, you get out on what is called a cash bond, which means you pay the full amount of the bond to get out of jail. You have a jail on a surety bond, which means that you pay the bondsman a percentage of the bond to get out of jail, or you're out of jail on what is called a PR bond, or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You was released under your own personal recognizance with a promise to appear in court. Say that to say this. Every day that you spent in jail, that jail time can be used as credit toward your punishment. Now, the operative word that I use is every day. Okay? And I'll explain it to you. Let's say, for example, you were booked in the county jail 11:59 PM on last night. And let's say you booked out of jail 12:01, 2 minutes later, 12:01 AM this morning. That's counted as 2 days. Yes, you've been in jail 2 minutes, but it's 2 different days, okay? Booked in on Monday, booked out Tuesday. 2 different days, so you get 2 days credit. It don't have to be a 48 hours, okay? And so for every day that you spent in jail, it could be used as credit towards your fine, towards your punishment. Now, let's say, for example, you spent 5 days in jail, state is offering you 5 days in jail, that means you don't have to serve no more time in jail because the time that you spent in jail, you'll be given credit for the time that you've already served. Now, if you spent 5 days in jail and they offer 7 days in jail, that simply means you won't have to spend 2 days in jail. Okay, because we'll subtract 5 from the 7, that leaves 2. Now, for every day that you spent in jail, and also you're credited $100 per day towards your fine and court costs. So, for example, let's say you spent 5 days in jail, state is offering fine and court costs of $500. You won't have to pay anything because the time that you spent in jail has already paid it off. We call that tax and retire. Now, if they're offering $700 fine and court costs, you spent 5 days in jail, which is $500. We'll subtract 500 from the 700 and leave 200. That means you would have to pay $200 fine and court costs. Now, if you can't pay it, then we can put you on what is called a payment plan, where you pay it off in small monthly installments till it's paid off. Let's say you still wouldn't have the income to pay it off if we put you on a payment plan. No problem. And we can convert it to community service. And every 1 hour community service that you perform, you will receive $12.50 credit towards your fine and court costs. So in 1 8-hour day, 8 hours of community service, 1 day, that's $100. So in our scenario, you work 2 8-hour days, your fine and court cost is paid off. All right. Now, Jefferson County has a program for first-time offenders. Let's say this is the first time having charges filed or 1 or more charges filed. They have a program where they will dismiss your case. And you can get it wiped off your record. The program that the district attorney's office has is called pretrial diversion. Okay? And in order to qualify for pretrial diversion, 3 things has to happen. You have to have an attorney with the application process. Now, an attorney don't have to be hired. You can get a court-appointed attorney to apply for it. 2, it has to be your first time getting in trouble. And 3, it cannot be an offense for unlawfully carrying a weapon or resisting arrest. For all other offenses, you can qualify. Now, if you are a veteran of any one of the branches of the United States military, the district attorney's office has another program that's called Veterans Court. But the Veterans Court program, you get into the program, you complete the program, they dismiss your case. And you can get a non-disclosure once you complete it, where your record is sealed to the general public. Or now, this court, County Court at Law Number 2, has a program that God led me to start within the first 100 days of taking office in March of 2017. The program is called the CSI program. CSI stands for Community Safety Initiative. It is a program that is designed to address the issue of what we call recidivism. What recidivism means, people commit crimes over and over. Okay? And so how do we address it? We address it through our CSI program to reduce it, to stop it. And in that program, we have partnerships with various agencies. One of the agencies that we have a partnership with is Spindletop. Spindletop is our local mental health agency. And Spindletop has the expertise to address mental health issues that a person may have. Okay? You don't have to be incompetent or insane to participate in the program. You can just merely suffer from depression or anxiety or any other host of mental illnesses. And Spindletop has the expertise to address those issues. Now, what Spindletop will do They can do a private interview either in our jury room at their facility or by telephone, whichever is convenient for you. They can do an assessment to determine what your mental health issue may be, and then they can develop a treatment plan to address your mental health issue. Now, if you have issues with drugs or alcohol, then Spindle Top also has a program, a drug and alcohol recovery program. Their program is called ATAR. It's an acronym, stands for it's ATAR. That stands for Addiction Treatment and Recovery. We also have a partnership with our local drug and alcohol council that has a program that is called OSAR, OSAR, that stands for Outreach, Screening, Assessment, and Referral. Both of those programs are designed to address individuals' drug and alcohol problems. Now, they can do a screening, an assessment to determine what the issue may be, and they can develop a treatment plan for either outpatient, inpatient treatment. Sometimes people have what is called a dual diagnosis or co-occurring disorder. What that simply means they have issues with drugs and they have mental issues. Spindle Top can deal with both. Now, if you are unemployed, or if you're looking for a better job, well, we have a partnership with Lamar University. Well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It's a job training program in the hotel industry, the chemical industry, and the shipping industry. Once you're trained in any one of those areas, they will help you to get a job. Okay? And if you do not have your high school diploma or your GED, they have a GED program where you can get your graduate equivalency diploma. Now, all of those programs that I just mentioned to you are free. It does not cost you anything but time. And I like to say in this code, we don't just give time. We take our time. And that simply means we do not just arrest the problem, we address the problem. And if we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so I'd like to say that when you come to County Court at Law Number 2 in Jefferson County, Texas, we do not just have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And if we make a difference in their life, we'll make a difference in their home. And if we make a difference in their home, we'll make a difference in the community, because what comes out of the home goes into the community. And so if you're interested in any one of these programs, just let us know, and we'll be happy to assist you at getting on the road to living your best life. Now, I mentioned to you earlier, we have some individuals. We have Mr. Johnny Stewart. He's with Family Services. Mr. Stewart, with Family Services, they have a program that's called BIP, Balanced Intervention and Prevention Program. With that program, if you have a family violence case, you get in that program, it's pre-trial diversion, your case is dismissed, and you can get it expunged from your record. Okay? Now, Mr. Stewart is going to come to you right now, and he's going to tell you more about the program that Family Services has to offer. Mr. Stewart.
Thank you, Judge. Good morning.
Good morning.
My name is Johnny Stewart. I'm the BIP Director with Family Services. Like the judge said, it's a violence intervention and prevention program. It used to be called the domestic violence programs, but it's for men and women. We have men and women's groups. And if this is your first time with a domestic violence charge, then you would have an opportunity to take advantage of this program. Okay. It's an 18-week program, and It's 2 hours per week, per room. And once you complete it, we will provide you a certificate of completion and, we're here, just like I was listening to the judge, he was saying, we don't arrest the problem, we address the problem. And that's what we're doing, we're providing tools and information to help you change those behaviors and keep you from coming back here again. So, if you have an opportunity, take advantage of the program, there's some flyers right here concerning the program. And we'll be looking forward to seeing you if you choose to enter that program. Okay, thank you very much. Thank you.
Okay, thank you, Mr. Doty. Now, ladies and gentlemen, we're gonna give you time to finish filling out the paperwork. If you need any assistance with filling out the paperwork, just let us know, just raise your hand. We have our core personnel here who will be happy to assist you with filling out the paperwork, that includes myself. Yes,
I do have a question. You said if we wanted to get a court appointment, but this page we fill out this part and this part.
yes, that's page 2 of the affidavit, yes. You gonna fill out the first page too.
Yes.
No, the first page of that document is, that page, when you fill out is a 3-page, no, that's a single page by itself. That's the first page, yes. You gonna fill that out, the financial stuff's at the bottom, yeah, okay, you got to fill it out, and then the second page. Okay, yeah,
I get it. So right here, that's your signature and.
yeah, I'll sign that, just sign where it says we finished. Okay, that's fine, we'll pick up the paperwork from you. If you need to use the restroom, there are 2 restrooms right out in the hall. There's the men's restroom in front of county court at law number 3. And then on the opposite side of the hall, we have the women's restroom in front of the 172nd District Court. Now, it's gonna take us a little time to, pick up the paperwork. Once we pick up the paperwork, we're gonna go over it, make sure everything is correct. We're gonna put you in the 3 categories. 1, you wanna hire your own attorney. And those who will be hiring their own attorney, case will be reset today. And the second category is if you want to apply for court-appointed attorney, then, if you qualify, you will be appointed a court-appointed attorney today before you leave. And then the third category, if you like to represent yourself, then you'll have an opportunity to talk to the prosecutors. If y'all come to an agreement on a plea bargain agreement, your case will be taken care of today. Okay? So, yes.
Yes, even me.
Yeah, okay, that's fine. And so we're gonna have anybody else, any other questions? Yeah, you can go use the restroom. Well, hold on, let me tell you this here. You're allowed to go use the restroom.
Yes, sir.
Now, when you finish, please come back in the courtroom. Do not leave the courthouse. If you leave the courthouse, your bond is gonna be forfeited. A warrant is gonna be issued for your arrest. You're gonna be arrested, placed in the county jail. You're probably gonna find out, and guess what?
Not just concern.
We're gonna have to go through this all over again. Yes.
I wanted to fix it right now because I had 2 letters. He had 2 trust papers from the both of them said, for today.
Oh, yeah, okay.
I don't understand why he got.
Okay, we'll get our court coordinator in here
Okay, thank you so
to
much.
find out.
Yes.
Okay? Anybody else? All right, now we're gonna be in recess. Make sure that you conduct yourself accordingly because even though we're in recess, we're still in court. Okay, now, okay, we're gonna be in recess. Court is in session and calls number 25 CCCR 0630. Case is styled the state of Texas versus Jennifer Franco. Ms. Franco, would you please come before the bench? Okay, Ms. Franco, you can leave your purse on that table. And Ms. Franco, you're gonna stand in front of the bench. Okay. Ms. Franco. Your full name is Jennifer Franco?
Yes, sir.
Ms. Franco, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Franco, you may put your hand down. How are you doing, Ms. Franco?
Good, how are you doing?
I'm doing fine, thanks for asking. Ms. Franco, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
Are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
On page 2 of the same document, there's a signature that's on the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Ms. Franco, before you sign and initial these documents, did you read the documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct
Yes.
to the best of your knowledge?
Yes, sir.
Ms. Franco, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney John Macy. Attorney Macy will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please
Thank
have a seat in the, please stand in front of the court coordinator to get your reset. Once you get your reset, you're free to go, and you have a blessed day.
Thank you, sir.
Thank you. Devontae Jackson. Mr. Jackson, your full name is Devontae Wayne Jackson.
Yes.
Mr. Jackson, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Jackson, you may put your hand down. How are you doing, Mr. Jackson?
All right, so.
I'm doing fine, thanks for asking. Mr. Jackson, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Sir.
Mr. Jackson, before you sign and initial these documents that I'm showing you, did you read the document?
Yes.
Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Mr. Jackson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Laura Peraza. Attorney Peraza will be given information to contact you, and you will be given information to contact her. Court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please stand in front of the court coordinator. Who do we have next? Yeah, no, he's still talking to somebody. Who do?
This is the last one I have, so where do you go, where do you have me?
Okay, let me just Amber Michelle Feener.
Yes, sir.
Okay, Miss Feener. Your full name is Amber Feener? Ms. Feener, would you please raise your right hand? Swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Feener, you may put your hand down. How you doing, Ms. Feener?
I'm done, all right.
I'm doing fine, thanks for asking. Now, Ms. Feener, I have before me a document that's titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
At the bottom of this document is a signature.
Yes, sir.
On the line that's titled Defendant, this is your signature.
Yes, sir.
There are a set of initials on a line that state you like to apply for court-appointed attorney. Did you place your initials on this document?
Yes, sir.
I also have another document that's titled Jefferson County Affidavit of Indigence. You recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Ms. Feener, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Feener, I read your answers. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Charles Rojas. Attorney Rojas will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day.
Thank you, thank you.
You're welcome. Nancy Morales? Come forward. Okay, let's see, your full name is Nancy Morales,
Yes, sir.
and Miss Morales, would you please raise your right hand? Yeah, you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
You may put your hand down. How are you doing?
How you doing, good, sir?
That's good. Now, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yeah.
And is this your signature on the line that's titled Defendant?
Yeah.
And you place your initials,
It's kind of gonna do it myself, but, my bond told me to just, she recommended me to grab the.
so you're gonna, your initials on the line that is state you would like to apply for a court-appointed attorney, is that correct? I also have a document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Now, Ms. Morales, before you sign and initial these documents, did you read the document?
Yes, sir.
Understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you, and you will be given information to contact him. Or our court coordinator will give you that information. Once you get the information, you'll be free to go, and you have a blessed day.
It's for all you too, sir.
Okay. Just have a seat in that first chair on the wall. Oh. Minnie Collins. Okay, Ms. Collins, your full name is Hermione Collins?
Hermione.
Hermione? Okay, all right, now, Ms. Collins, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Ms. Collins? I'm doing fine, thanks for asking, Ms. Collins. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line state you'd like to apply for court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yeah.
On page 2 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Ms. Collins, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, Ms. Collins, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Nathan Reynolds. Attorney Reynolds will be given permission to contact you, and you will be given permission to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go. But before she gives you that information, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. And I'm going to go over this document with you.
Okay.
And do you have the document before you?
Yes, sir.
Okay. And it states, following return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test of drugs and alcohol when directed to do so by the court, or B, submit to a test of drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number 3 states that the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Then condition number 4 does not apply. However, on page 2, condition number 5 does apply. And condition number 5 states, defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by section 1.07 of the Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Not really. You just kind of lost me a little bit with the
Okay,
peace officer part after that part.
it says defendant, I'm gonna read it again. Defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer
Okay.
as defined by section 1.07 Penal Code, actively engaged in employment as a sworn full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, condition number 7 states, defendant shall wear a global positioning monitoring system device at defendant's expense with written verifications being submitted to the court within 3 days. So you have to get a GPS. Okay, sometimes they're commonly referred to as an ankle bracelet. Okay,
Okay.
and we have some places that you can get that from. And you need to provide proof to us within 3 days. You can either bring proof to the court. We have a clerk that sits by the window. There's some blue doors next to this court. She sits at the window and you can bring it to her and she'll get it to us. Or you can bring it in the court, or you can email it and they'll give you the email address
Okay.
or fax. All right. So you're going to get your reset. Once you get your reset, you're free to go and you have a blessed day.
Thank you.
Now, just be mindful that if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be placed in Jefferson County Jail. Do you understand?
Yes, sir.
All right. I think she needs to. Okay. Jefferson County Court at Law number 2 is back in session. Court is in session and calls number 25 CCCR 2948, case of style of state of Texas versus Zeno Joseph Jr.
Yes.
Mr. Joseph, is that your full name?
Yes, sir.
Mr. Joseph, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, except you got?
I do, Your Honor.
Mr. Joseph, you may put your hand down. How are you doing, Mr. Joseph?
I'm good. How you doing?
I'm doing fine, thanks for asking. Now, Mr. Joseph, the state is represented in this case by Attorney Cornelius Williams. Attorney Williams, how are you doing?
Excellent, Your Honor. Thank you. And how are you and your staff?
We're doing fine, thanks for asking.
You're welcome.
And Mr. Joseph, before we get started, I must inform you that you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. You waive or give right to have a court reporter?
I do, sir.
Okay. Now, Mr. Joseph, before me, 2 documents on paper. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
I do, sir.
Is this your signature on the line that's titled defendant?
It is.
Or are these your initials on the line that state you would like to waive your right to an attorney and represent yourself?
They are.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled
It
defendant?
is.
Now, on my computer, I have a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Zeno Joseph Jr., on or about September 25th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of possession of a controlled substance, penalty group 2A, less than or equal to 2 ounces. Mr. Joseph, do you understand what you have been charged with?
Yes, sir.
To this charge, how do you plead guilty, not guilty, and no contest?
No contest.
Are you pleading no contest freely and voluntarily?
I am, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Joseph, I also have another document on my tablet that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
I do, sir.
On page 2 of this document, there are 2 sets of initials, ZJ. The first set of initials are on the line next to a box that's checked nolla contendere, which means no contest. Did you place your initials in this
I did, sir.
on this line? The second set of initials are on the line next to a statement that states, I do not request discovery in this case. I waive my right to discovery, and I choose to enter a plea of guilty or no contest. Did you place your initials in the second location?
I did, sir.
On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
It is.
On the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
I do, sir.
Is this your signature on the line that's titled defendant?
It is, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that
Yes,
statement?
sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Joseph, before you signed and initialed all of the documents that I showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
I did, sir.
Is everything in these documents true and correct to the best of your knowledge?
They are, sir.
Mr. Joseph, are you a citizen of the United States?
I am, sir.
The state will offer State's Exhibit Number 1 to the court, Judge.
Mr. Joseph, the state is offering State's Exhibit Number 1 as the evidence to be used against you. State's Exhibit Number 1 is the first document that I showed you on this tablet. First document that you acknowledged. This is the same document that has your initials in these 2 locations, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case? Okay, no objections. State's Exhibit Number 1 will be admitted. Now, Mr. Joseph, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Okay, Mr. Joseph, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt state. Do we have a plea bargain agreement
We do,
in
Your
this
Honor.
case?
We do, Your
And
Honor.
what is the agreement?
60 days time served, time actually served, but we requested all court costs be taxed and retired. Is that your understanding?
It is.
Okay, Mr. Joseph, the state is offering that you serve 60 days in Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail because you've already served 60 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. What that simply means is you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Mr. Joseph, do you understand the state's offer?
I do, sir.
Do you think that the state's offer in your case is fair and just?
I do, sir.
And do you accept the state's offer?
I do, sir.
Mr. Joseph, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Joseph, you're gonna stand at the end of that table and follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go and you have a blessed day.
Yeah, you also.
Thank you. Kevin Larnell Russell.
How you doing, Your Honor?
I'm doing fine. I'm Mr. Russell. Your full name is Kevin Larnell Russell.
Yes, sir.
Mr. Russell, would you please raise up your right hand? Mr. Russell, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Russell, you may put your hands down. Now, Mr. Russell, how are you doing?
I'm doing well. Thank you for asking.
You're welcome. Now, Mr. Russell, I have before me a document that is titled information. Well, first of all, before I do that, Mr. Russell, as a defendant in a criminal case, since you're pro se, you have a right to have a record made. And what a record is where the court reporter can type down everything that's being said. You also have a right to waive or give up the right to have a record. You waive or give up the right to have a record?
Yes, I do.
Okay. Mr. Russell, I have before me on paper document, well, two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir, I do.
And is this your signature on the line that's titled Defendant?
Yes, sir, it is.
Or are these your initials on the line that state you would like to waive your right to an attorney
Yes, sir.
and represent yourself?
Yes, sir.
I also have another document on paper that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes, sir, I do.
And is this your signature on the line that's titled Defendant?
Yes, sir, it is.
Please sign in both spots.
Yeah, my apologies.
Okay. Now, Mr. Russell, I also have before me a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Kevin Larnell Russell, on or about October 4th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of unlawfully carrying a weapon. Mr. Russell, do you understand what you've been charged with?
Yes, I do.
And to this charge, Mr. Russell, how do you plead? Guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily?
Yes, sir, I am.
And are you pleading no contest because you do not wish to fight or contest the charges.
Correct.
Mr. Russell, I also have before me a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, I do.
On page 2 of this same document, there are two sets of initials. The first set of initials are on a line next to a box that's check nolo contendere, which means no contest. Did you place your initials KR on this document?
Yes, sir, I did.
Second set of initials is on a line next to a statement that reads, I do not request discovery. I waive my right to discovery and choose to enter a plea of guilty or no contest. And did you place your initials in the second location?
Yes, I did.
On page 3 of the same document, there's a signature above the line that's titled defendant. Is this your signature?
Yes, sir.
And on the next document, it's titled trial court certification of the, let me do this here. I'm gonna go back. Apparently, this your signature on this?
Yes, sir.
document?
Yes, sir.
So the previous one was initials. You can go ahead. I'm gonna erase your initials. Let's see.
But I had him place it in wrong place. I marked X, sorry.
Okay.
No. He just put his initials where it says, where his signature is supposed to be. Okay, have him to, he can sign his signature.
Yes, sir.
Okay, now, Mr. Russell, is this your signature on page 3 of this
Yes, sir.
document?
Yes, sir.
Okay, the next document is titled trial court certification, defendant's right of appeal. Do you recognize this document?
Yes, sir, I
And
did.
is this your signature on the line that's titled defendant?
Yes, sir, it
At the
is.
top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right to appeal. Do you understand that statement?
Yes, sir.
The second box that's checked states that you're waiving your right to appeal, which means you're giving up your right to appeal. Do you understand that statement?
Yes, sir.
Now, Mr. Russell, before you signed and initialed all of these documents that I've shown you, did you read the documents?
Yes, sir, I
Did you
do.
understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
And state, you like to offer state's exhibit number 1?
So offered, Your Honor.
Mr. Russell, the state is offering state's exhibit number 1 to be used as evidence against you in your case. State's exhibit number 1 is the first document that I showed you on the tablet.
Yes, sir.
This is the same document that has your initials in these two locations. And it has your signature on page 3. Is it all right for the state to use this document as evidence in your case?
Yes, sir.
No objection. State's exhibit number 1 will be admitted. Mr. Russell, are you a citizen of the United States?
Yes, I am.
Mr. Russell, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
The agreement will be 5 days in the Jefferson County Jail, time served, time actually served. All court costs will be taxed and retired, and a forfeiture of the pistol, of the weapon, Your Honor, to the Beaumont Police Department.
Okay.
Is that correct, sir?
That's correct.
Yeah.
Mr.
Thank you,
Terrence,
Mr. Russell.
Thank you.
You're welcome, Mr. Russell.
Okay, Mr. Russell. The state is offering that you serve 5 days in the Jefferson County Jail. However, you will not be required to serve any more time in the Jefferson County Jail because you've already served 5 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case will be taxed and retired. It simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the courthouse will be taxed and retired. I also have before me a document that is titled Motion to Forfeit a Weapon. Do you recognize this document?
Yes, sir, I do.
And is this your signature on the line that's titled defendant?
Yes, sir, it is.
Now, before you sign this document, did you read the document?
Yes, sir, I did.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir, sir.
Mr. Russell, the court is going to grant this motion to forfeit the weapon in this case to the Beaumont Police Department. Okay, now, Mr. Russell, the court is going to grant this motion to forfeit the weapon in this case to the Beaumont Police Department. Now, Mr. Russell, do you understand the state's offer?
Yes, sir, I do.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir, I do.
Mr. Russell, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Russell, you're gonna stand at the end of that table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you're free to go and you have a blessed day.
Yes, sir, y'all do the same, all y'all.
Okay,
Good luck to you.
Yes, sir, you too. Thank you, sir.
You're welcome.
okay, Hassan Mahoney,
You know, when you go down, just go down and roll it, lower it, go down. I will bring in the bottom track. I lay on good night.
okay, Mr. Mahoney. Your full name is Hassan Mahoney. How are you doing?
I'm blessed.
You're blessed? It can't be better than being blessed. That's right. That's the best you can be. Now, I see that you have some folks with you today. Your mom and dad. Okay. Thanks for coming down here with your son. Now, State, I have before me a motion to dismiss the case against Mr. Mahoney. Is that correct?
That is correct, Your Honor. The
Okay.
state does not believe the substantive end of justice would be served by the continued prosecution of this matter, Judge.
Okay. Send that back to me. What? Did I sign it? Yes, okay. I'm signing the motion to dismiss. And so, Mr. Mahoney, these charges are dismissed. You no longer have criminal charges against
Thank you very
Yeah.
much.
you. Okay, yeah, you're gonna get a copy of this here. And I think we gave your mother the form for the
Yes.
work program.
Mhm.
And just keep up the good work. I know you told me you're doing t-shirts.
Yes, it does t-shirts.
That's good. And with scriptures on it.
Yes.
That's good. Just keep up the good work. I see you're doing a good job.
My God t-shirts and God is good t-shirts.
That's right, because God is good all the time.
All the time. Thank you
Okay.
so much.
And y'all have a blessed day.
Okay, thank you, Judge.
Okay, you're welcome.
All right. Okay. Let me get Sean. Sean.
And let's see. Jefferson County Court of Law number 2 is back in session. Court is in session and calls number 25 CCCR 2592, case style, State of Texas versus Hafe Feliz Matos. Hafe Matos was scheduled to be in court this morning at 9 a.m. At about 9 a.m., bears called the name of Hafe Matos at the courthouse door. Hafe Matos did not answer. He has not appeared in court since the court has been in session. His time now is 11:58 a.m. on today's date of March 3rd, 2026. Mr. Bailiff, would you please call the name of Hafe Matos at the courthouse door? Hafe Matos? Hafe Matos? Hafe Matos?
No response, Your Honor.
Okay, Hafe Matos' name was just called again at the courthouse door. Hafe Matos did not answer. A reasonable time has passed to give Mr. Matos an opportunity to appear in court. He has not appeared in court. State, do you have a motion to forfeit the bond?
Yes, Your Honor.
Okay, court is, Hafe Matos' bond will be forfeited and a warrant should be issued for his arrest in clause number 25 CCCR 2592. Next case is clause number 23 CCCR 1676, case to style the State of Texas versus Cologne Jones. Cologne Jones was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court will call the name of Cologne Jones at the courthouse door. Cologne Jones did not answer. Reasonable time has passed to give Mr. Jones an opportunity to appear in court. He is not appearing in court. The time now is 12 noon on today's date, March 3rd, 2026. Mr. Bailiff, would you please call the name of Cologne Jones at the courthouse door? Cologne Jones? Cologne Jones? Cologne Jones?
No response, Your Honor.
Okay, Cologne Jones' name was just called again at the courthouse door. Cologne Jones did not answer. Reasonable time has passed to give Mr. Jones an opportunity to appear in court. He has not appeared in court. And State, do you have a motion to forfeit the bond against Cologne Jones?
Yes, Your Honor.
That bond will be forfeited. Warrant should be issued for his arrest in cause number 23 CCCR 1676. Next case is Larry Walton, cause number 25 CCCR 1408. Larry Walton was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's barely called the name of Larry Walton at the courthouse door. He did not answer. He has not appeared in court since the court has been in session. The time now is 12:01 p.m. on the day's date, March 3rd, 2026. Mr. Bailiff, would you please call the name of Larry Walton at the courthouse door? Larry Walton? Larry Walton? Larry Walton?
No response, Your Honor.
Okay, Larry Walton's name was just called again at the courthouse door. Larry Walton did not answer. Reasonable time has passed to give Mr. Walton an opportunity to appear in court. He is not appearing in court. State, do you have a motion to forfeit the bond of Larry Walton?
Yes, Your Honor.
Larry Walton's bond will be forfeited. Warrant should be issued for his arrest in cause number 25 CCCR 1408. Next case is Raya Young, cause number 2524 CCCR 0414. Raya Young was scheduled to be in court this morning at 9 a.m. At about 9 a.m., the court's bailiff called the name of Raya Young at the courthouse door. She did not answer. She has not appeared in court since the court has been in session. The time now is 12:03 p.m. on today's date of March 3rd, 2026. Mr. Bailiff, would you please call the name of Raya Young at the courthouse door? Raya Young? Raya Young? Raya Young?
No response, Your Honor.
Okay, Raya Young name was just called again at the courthouse door. Raya Young did not answer. Reasonable time has passed to give Ms. Young an opportunity to report. She has not appeared in court. State, do you have a motion to forfeit the bond of Raya Young?
Yes, Your Honor.
That motion will be granted. Raya Young's bond will be forfeited and the warrant should be issued for her arrest in cause number 24 CCCR 0414. And this will conclude the calling of the court's arraignment docket on the day's date, March 3rd, 2026 in County Court at Law. Number 2 of Jefferson County, Texas, Judge Terrence Holmes presiding. Court will be in recess until 1:30 for us to resume with the trial that we have. Prosecutors, your excuse.
Thank you.